Jim, throughout this whole series, we've talked about laws that will be affected if Prop 3 is allowed to pass. Why is that? What will Prop 3 and this constitutional amendment do to make those laws change?
Well, I think we need to get kind of the overall big picture of this.
Okay.
When our country was created, we passed a constitution between the 13 states. That constitution is the very basic and fundamental law of the country. That's the United States Constitution.
Okay.
It's a constitution that provides limited powers to the federal government. Under that constitution, Congress can pass some laws. If it passes those laws in accordance with the Constitution, those laws govern the entire nation. So under the Supremacy Clause of the United States, the U.S. Constitution and congressional laws have supremacy over whatever states do. Now let's move, but remember that the Constitution and what Congress is entitled to do is fairly limited in its scope.
Sure.
That leaves a lot of stuff that Congress can't do. That's left to the states and to the people.
Mm-hmm.
So now when we come down to the state level, say in Michigan, Michigan has a constitution. That is the very basic law of our state. The people adopt that. And the legislature can't do anything that violates the Michigan Constitution. The governor cannot do anything. Administrative agencies cannot violate that basic law. Townships, cities,
you and me.
yeah,
Sure.
you have to obey that basic law. So if we have a constitution that sets out the scope of what you can do with regard to reproductive freedom, the legislature can't come in and pass a law that contradicts that Constitution.
Mm-hmm.
If there is a law that is existing which is not consistent with the Constitution, that law cannot be enforced. It will be held unconstitutional and unenforceable.
Okay.
So the Constitution for the state of Michigan is really crucial. It is our very basic and fundamental law. So I guess that is why certain laws would be held unconstitutional, because they are not in compliance with Proposition 3 should it pass.
Just kind of to sum that up a little bit, for example, in Section 2 of the constitutional amendment, it says the state shall not discriminate in the protection or enforcement of this fundamental right. And in earlier videos, we had talked about the Elliott-Larsen Civil Rights Act, and in there are many check marks of discrimination that says you cannot discriminate on age, you cannot discriminate on gender, sexual preference, things like that, right?
Right.
You're saying that once this becomes, because this is an amendment to our Constitution, once this goes into the Constitution, now the House of Representatives, the Michigan State Senate, they cannot do anything to regulate age or say that only this applies to women, right? No, this also applies to men, right? Like, it's because it says in Section 1, every individual has the fundamental right. This is now laid into the Constitution, the bedrock of our society, and our elected officials who we send to Lansing can't do anything to change that, and if they try, they'll be ruled by the Michigan State Supreme Court as unconstitutional.
That's correct. And I don't think you can treat prenatal care different from childbirth, different from contraception and abortion, and those things, say with regard to, as we talked before, parental consent.
So interestingly, too, we talk about here, you were just listing the first sentence in Section 1, and it talks about all matters and decisions relating to pregnancy, including but not limited to. Correct. And you had just said, you know, postpartum care, contraceptive, sterilization. But what about the ones that aren't listed in this list in Section 1, or Sentence 1?
I don't think you can discriminate between those either.
But what are those? And how those will come up, but those will come up at the court level, won't they?
Yep.
So someone will have a case, they'll feel discriminated against, they'll get with a lawyer, and then a lawyer would file suit, and that would make its way to the courts, and whatever that outcome is, then that would be added to this list.
Yeah, if it's a matter relating to pregnancy. Yes.
Okay.
Yeah, so, and you've got to treat that the same as you do all other matters relating to pregnancy.
So it's very, very broad once this enters the state constitution.
Correct.
So what are then, I guess, let's spend a couple minutes, what are some laws that you've, in your research, have come across that will be affected if Prop 3 is allowed to pass?
Well, I've kind of have a list here, so let's just
Yeah.
talk about them. Now, I'm not guaranteeing you that, I don't know how a court's going to rule 100% on these, but these are laws that the legislature has already in place that I think have a potential for being held unconstitutional. Partial birth abortion. Now, people could very well say, well, partial birth abortion doesn't occur as a general rule until viability. And then after viability, the state can regulate it.
Sure.
So, and I would agree with that. Post-viability, the state can't prohibit partial birth abortions.
Can prohibit.
No, they can't. They can't regulate it before viability.
Oh, before
no
okay,
regulation
right,
before.
Right.
After viability, I suppose the legislature could still pass a law that says after viability you can't have partial birth abortions. Well, okay, that's a nice law, but what teeth can you put into it? Because remember, when you looked at Section 3
Yeah.
of it, it says a state can't take any adverse action for someone aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. So if a woman comes in and asks for an abortion and the doctor decides to do a partial birth abortion, even though the law says, even though the legislature said you can't do it, how can you penalize the person that assists in it? There is a current statute also that has to do with, okay, if you have an abortion and for some unknown reason the baby lives after the abortion, I call it a botched abortion. Right now, the law says that if there's an abortion, if an abortion results in a live birth, and if the mother says, hey, I don't want anything to do with that child, you have to take that child and put it under the custody of the state.
Mm-hmm. I also was reading that if the child needs medical care, 911 must be called and medical attention must be given to that birthed child. That's currently on the books right now.
Well, here the mother has the right to make decisions regarding to the postpartum care. And if she says, no, I don't want that baby to be treated, I think she has the right to say that. And a law requiring this baby to be put in the custody of the state or call 911, I think that would infringe on her right. So I think those laws would be held unconstitutional.
Okay.
We talked about parental consent of a minor, and that currently the law requires that both a minor and a parent consent unless there's a waiver of the parent's consent by the probate court. I think that law would probably be held unconstitutional. Currently we have laws, or a law in the book that requires informed consent before you can have an abortion. And the informed consent is quite extensive in the statute if you read it. And it includes such things as telling them about the risks and the complication, requires them to provide, the medical provider to provide a picture of the fetus at about the same gestational age, an opportunity to view the ultrasound if one had been taken, and so forth. It seems to me that putting these additional requirements of voluntary consent would infringe upon the person's right to obtain an abortion. I think those probably would be, or that law would probably be questioned.
And in a way, those informed consent laws go against an individual's autonomous decision-making as well.
It does. And when you read the amendment, it doesn't discuss informed consent. It talks about voluntary consent. And although it seems like a minor difference, there is a difference making a decision based upon information and then consenting to it, or just voluntarily agreeing to voluntarily deciding something that you really don't know much about. We also have another statute on the book that limits school employees like teachers and janitors and counselors and so forth from assisting students to obtain an abortion or to prevents them from referring a student for an abortion. Right now, or if this proposition passes, you recall it says that you can't take any adverse action against someone for aiding or assisting a pregnant individual in exercising their right to individual freedom. So I think that statute that limits what teachers and counselors at school can promote to the children and encourage them to do would be held unconstitutional.
And if you did try to limit it to what teachers could do, that would be discrimination, which says you can't do it in Section 2.
Exactly. Yeah. And then another thing we have a statute on has to do with the tissue from the fetus after an abortion. I think the idea is we don't want people getting pregnant and then having abortions in hopes of making some money off of selling the fetal tissue or using the fetal tissue as payment for the abortion. So we currently have a statute on the books that says that no one can do an abortion or offer to do an abortion where part of the payment for that abortion is receiving the fetal tissue. Now, in the past, we talked a little bit about the Michigan Elliott Larson Civil Rights Act.
Yeah.
And that if this amendment passes, it probably would prevent a hospital or doctor from refusing to perform an abortion. Didn't go into it in a lot of detail at that point, but at this point it doesn't prevent them from doing that because we do have statutes on the books. One that says that a person who objects to performing abortion, say a doctor, on ethical, moral, or religious grounds, doesn't have to do it and cannot be held liable for doing that, for refusing to do that. Mm-hmm. So right now, under current law, you can do that. We also have another statute closely related that says that a hospital or a clinic, they're not required to admit a person for an abortion. But now if this amendment should pass, you see that treats abortions differently or different than childbirth,
Yep.
other matters relating to pregnancy.
Yep. Postpartum care.
Yep. And this amendment says you can't discriminate. The state can't discriminate
Right.
Based among these fundamental rights. And here, these two statutes that allow a hospital and medical providers to refuse to provide care for abortions, it's discriminating. It's treating abortions differently than other reproductive rights.
And they can't make a provision, and I think you said this in our religious liberties video, but the state can't make a provision separating the city hospital from, let's say, the Catholic hospital or Presbyterian hospital. They can't do that.
It seems to me that would be an unlawful discrimination. So at a very minimum, these will be challenged, and they will be challenged very, both sides will be very intense on the challenge here. I wouldn't be surprised statutes like these, that the final word will not be the Michigan Supreme Court, that they will probably get up to the United States Supreme Court. The other thing, another statute that treats abortions differently than other type of medical care has to do with public funding of abortions. You know, under Medicaid and so forth,
Yeah.
The public pays for certain medical care for people who are low income. We currently have a statute that says that no abortion services can be provided with public funds. And again, I would think because it treats abortion differently, that statute would be held unconstitutional. There's another law that we have now that says that you can't advertise or publish any type of medications, whether it's pills, powder, whatever, that are designed for the use of procuring an abortion, like the after morning pill. And I don't think you ever see that on TV because this statute makes it a misdemeanor to advertise abortion pills.
Yeah.
Now, again, here you're treating abortion entirely different than other types of reproductive care.
Yep.
So it seems to me that, again, that's discriminating between the reproductive rights, and I would think this would be held unconstitutional, and you'll start seeing ads on TV.
Well, and I think, too, if you look at Section 3, nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. It's definitely a penalty if you're a manufacturer of an abortion aid, but you can't show it in the state of Michigan. Look at that,
Right.
Those millions of people I can no longer advertise to. That's a penalty.
It's an infringement, yes.
And so therefore an infringement. So
Yeah.
they'll be able to do it.
Oh, I think so, absolutely.
Yeah.
Yeah, I think you'll start seeing after morning pill ads coming on TV.
So
should this
the
pass.
morning after pill will have one of the biggest Super Bowl ads this year in Michigan, you think, or something. I pray that's not the case. But thank you for showing us what laws may or what laws can be challenged if Prop 3 passes. Please read the full language of the constitutional amendment that I've supplied here on this page and know what you're voting for this November 8th. Thank you.